Okay, so we're now recording the meeting. We'll take roll. Bashan.
Present.
As far as I can see, Stephen Hamilton is not present. McRae.
Here.
Olvera.
Here.
Sarouche.
Here.
Okay, great. So I prepared a very brief slideshow just to guide our conversation today. And just to basically to show where we stand with the recommendations so far. So these are the recommendations that were presented, at the meeting on August 25th, which is the point at which we decided to sort of set this discussion aside and move on to the licensing, regulation, and discipline topics. So this is where things stand. So we have the subtopics, and I'll come back to this. We have the subtopics and then the specific tasks. And as you can see, some of them there was already decision to include, and there were a couple that were left to be determined in terms of whether they would be included or not. This was a discussion, and then once we after we get through the subtopics, then we have the tasks. Let me pause for a moment because I see there is someone who has their hand raised for public comment. So maybe before we get into the slideshow, so this is just sort of the background of what we're going to discuss today, or a proposal of what we might discuss today. But in the meantime, let's go ahead and do the public comment. We have a couple of people who are asking to talk. If anyone else is interested in making public comment, please use the function of raising your hand that Zoom provides, and then I'll call on you. So I will start with Betty Nordwin. So if you can unmute yourself and you can begin speaking.
Hi, thanks for the invitation to speak. Can you give me an idea of how long? I was trying to get a sense of it. Is it 2 to 3 minutes? Is that my understanding?
Let's just say 3 minutes.
Okay, thanks. I don't know any of you except Sharon, and you don't know me, so I'm going to just quickly tell you that I do feel very passionately about what you're doing, what you're embarking on, and I thank Sharon for keeping me informed. I've been the director of the Harriet Buhai Center for Family Law in Los Angeles for 37 years. I've been a lawyer for 50. The Harriet Buhai Center for Family Law is by definition family law. I will tell you very, very briefly in a moment, but I do want to tell you in my capacity at the center, I have personally handled hundreds of cases, supervised hundreds of people, and trained hundreds, and some of these numbers might be in the thousands. The clients are all low income. Currently, our eligibility is, we get state bar pro bono money, so our income level is higher than the traditional legal aid program, the LSC program. We're not an LSC program. And for example, one person's income right now is about $2,000 a month. Our average income for a client with one child is right now about $1,400. I believe sort of on this topic that you are addressing, I know it's self-aggrandizing, but I believe that if there is an expert in the state of California, I may be it on the things that you are looking at. And I'm speaking quickly because I want to keep within the time limits. Since approximately 2006, and we ourselves were formed in 1982. Since approximately 2006 in particular, we have been, when the self-help program in California started, we have done a great deal of front-end analysis about who we should be serving and where else they can get help. I feel like I'm an expert on this topic. We spend a great deal of time at doing a factual analysis that helps us decide whether we should keep the case or give it to self-help or give it to another legal aid program or give it to Levitt and Quinn, which is a fee for service below fee. So we've literally, we're looking at thousands of cases, okay? We're trying to reserve our resources for those in need that are not necessarily going to be taken by another legal aid program or self-help. And
so you
the
were past
direction I'm going.
your 3 minutes of time if you want to wrap up.
Okay. I would tell you that based on my experience, the direction that you are heading in, to decide cases based on the chart that I am looking at on the screen, I couldn't disagree with you more about that approach. We would never, ever look at a case and just say, okay, if it's a dissolution, it can go here. If it's you have to have a case assessment. You can be looking at pleadings. They can be totally different. To say that, the paraprofessional can do a petition when you're looking at someone who's been married 25 years or someone who's been married 2 years. I think that the direction you are going in to even start thinking about who is a paraprofessional and or what they should be handling is quite wrong-headed. My suggestion is, and I don't believe you're also you're addressing some really pressing needs in California, one of which is people without income who have property matters, such as extensive equity in houses and retirement plans, both of which our office handles. My recommendation is that you do need some guidance in depth from people who actually have been really doing this in-depth work, who are doing it for 5 or more years. I think you need an advisory to your group who can sort of really sit down and say, if we are going to parcel out work to people who are, not lawyers, how do we figure out what it is that they can be asked to do? Thank you.
Thank you. Okay, so next we have Juliana Lee.
Hi, I hope you can hear me.
Yes.
Okay, great. So this is Juliana Lee. I'm a supervising attorney at the Legal Aid Foundation of Los Angeles, and I manage the family law work at my office. Thank you so much for having this public comment period and for your work on the subcommittee and the paraprofessionals work group. So myself and along with several other family law legal services organizations submitted written comments to the subcommittee and the working group, which I hope you were able to see and consider. And I thank you in advance for reviewing that. I'd like to speak briefly about the possible recommendation that paraprofessionals would engage in court representation. Even without that piece, I think we're looking at a dramatic change of the current legal landscape of legal services and who is able to provide not just legal information and document prep assistance, but legal advice and drafting of motions and argument, based on law, case law, and legal research. That in itself is a huge kind of change from where we are, and I think that while we recognize there's a big need, and that need falls in many different places, that adding things like court representation and kind of making these dramatic changes will not necessarily be helpful if they aren't designed with an informed and studied approach at each step. And so instead of kind of viewing this as this one moment we have to fix all these things and provide all of these services, I would urge this body to consider kind of if it's moving forward with this, to potentially a pilot and to move forward slowly and very conservatively, so that as things are opened up, it's done so kind of in prudent ways. These are major proposals as they stood before court representation was considered, and lines for what are appropriate tasks for paraprofessionals are difficult to draw. but court representation seems one that is relatively easy to draw. Once in the courtroom, there's a slippery slope that could quickly change the role of a paraprofessional that creates inconsistency and confusion and potentially significant discomfort by many. So thank you. I hope in this and other meetings that legal aid organizations will be able to kind of have a voice and be included in the discussions. Thank you.
Thank you. We have no other comments. So what I would, there's nobody else who's indicated an interest in speaking. And I see Stephen has joined us. Hi, Stephen.
Good afternoon. Thank you.
So, just to go back to the very few slides that I prepared for this meeting, just wanted to remind the subcommittee where things stood at the last meeting. So at the August 25th meeting, this was the status of recommendations regarding the subtopics to be included in a family, children, and custody. And then there also was the discussion of the specific tasks. So my suggestion is that we revisit the topics that are under the to be determined category with an eye toward developing a more detailed recommendation to bring to the working group at the December meeting. That's just a suggestion. If the members of the subcommittee want to approach this differently, I'm happy to do that. We have this meeting and 2 more meetings scheduled. So if there's information that you'll want the staff to bring at future meetings, we'd be happy to do so. But so with that in mind, I just want to open this up to see where you want to go with this.
I wonder if, oh, I'm sorry, Steve. I was just going to say, I'm not sure if, I think Betty Norman from Harriet Bohai Center, one of the persons who made a public comment just now. Not sure she's familiar with me and Stephen, and she was recommending that we bring on advisors who understand the area, and I wasn't sure if she knows who I am, and I consider myself a subject matter expert as well. Not trying to be pretentious here, but I've been in the supervising attorney here at the Self-Help Center Family Law Facilitator for Santa Clara County Superior Court since 1998. So I have quite a bit of experience in the self-help area, dealing with low-income individuals and also family law. And before that, I had my own family law practice litigation. I do a lot of mediation. So I'm familiar with all aspects of the topic that we're discussing here and all the factors that are at stake, and I don't take them lightly. I know that Steve can speak for himself, but he's also very experienced, and Dana and Elizabeth can talk for themselves, but and Sharon as well. So I just wanted to say that, there is subject matter experts here on this panel, but doesn't mean we can't use more guidance. We just wanted to let you know.
So I'll dovetail. I actually really appreciated the letter that we got from the Legal Aid Foundation. I spent the morning reading it and reviewing it. Some of the comments echoed things, just so that you know, from the public commenters, things it said, and I was able to share with others. I mean, there were heavy hitters that were on that letter. I mean, the work of the Harriet Buhai Center is extremely well known among family law practitioners. The same for the Family Violence Appellate Project. I mean, their fingerprints are on probably 50% of the successful domestic violence appeals that have been filed in the last 10 years. So like Fariba, I've got a pretty extensive background in family law. I've been a family law practitioner for 25 years, a certified family law specialist for 16 years. I'm a fellow in the American Academy of Matrimonial Lawyers. So when we put some of these things up here, when we put up your dissolution, we were not referring to the entirety of a dissolution proceeding, just that much as a LDA could currently do, or someone could do by going to the family law facilitator, someone could file that petition for dissolution and process the dissolution judgment, just that aspect of it alone, not dealing with any property issues, not dealing with any child custody issues. The same with parentage, is just offering another level of assistance. But again, I'm very mindful. A lot of the comments that were in that letter were things that I have been, I would say, sojourning. Like, I particularly appreciated the comments about a trial program and the approach that we take. But I would join in Farida with saying that the people that have joined this subgroup do have an extensive amount of experience in family law. And mine is over a broad spectrum because I've represented a lot of different socioeconomic groups over the last 25 years. I also have been very active in representing minors. I led the San Luis Obispo County Minors Council training for the last 4 years, which pretty much became the Minors Council training program in the state of California. We had typically in the last 2 years over 100 people from over 27 counties coming. So.
This is Sharon. Like everyone else, I took that letter very seriously, and I think that there were a lot of very good salient points. I am wondering, and I've spent the morning like reading the letter and then also going back to refresh my memory on the Minnesota program. And I'm wondering if this subcommittee would consider looking at what they're doing, excuse me, I've got a cold, in Minnesota. Just I know that they're taking like a more prudent approach. It's a more conservative approach. And in the area of family law, where there's like so much at stake, it's people's children, it's their families, if we might consider an approach like that one as we move forward.
I'm definitely open to that. It's this really tough struggle. We want to create a program that's robust, that can survive, but we can't do that at the risk of jeopardizing, even one bad outcome in one case could create results that we would regret not having taken a more prudent approach. So I actually like your suggestion, Sharon.
Thanks.
So I guess we got to go back to the actual work now, right?
One thing I wanted to mention, if I could, is just that, before we start looking at Minnesota, start looking at Texas and all these other programs, we have to remember what's being done here in California, because the needs of the people and in this community are very diverse from other places. And I just wanted, again, just bring that up again, because we have the people who are already working with the proposed target demographic that this program would help. And so I just want to remind that we should probably look more into what our LDA is doing for the public.
I wanted to add to Elizabeth's comments that first off, I also appreciated the letter. Just the comments were right on point. And as Steve said, we are not done yet. I mean, we're going to talk about complexities today. But one thing I want to point out is, even if we decide, scrap this is not going to work, leave it, there's a group of people out there that are providing these services who are not regulated. They don't need any kind of license. They don't need any kind of training. There's no kind of oversight. And I suggest, for consideration of the good people that wrote this letter and are objecting to this program, is that at least this, in my opinion, this provides a way to regulate the industry and be able to require expertise and impose professional rules of conduct and licensing requirements. And I suggest that that's much better than what's going on right now. You're not going to be able to stop these people from putting up a sign and saying they can do all kinds of things. But at least this way, we can make an attempt to regulate that industry and require some sort of training. And I hope that is a source of comfort.
What about the suggestion, because it was prominent at the end of the letter, about a trial program?
A pilot, I think.
Pilot program.
Yeah, in yesterday's meeting, we had the regulation subcommittee meeting, and there was a public comment. Maybe it was the same person. I don't, no, it wasn't the same person, but they were recommending a pilot as well.
I
Is
think,
that-
can you guys hear me? I'm sorry.
Oh, hi, Leah.
Yeah,
I had another meeting, and then my internet is down in my house. I'm on my phone, but I'm making it happen.
Nice background, by the way.
Oh, what is it?
It's like a meadow.
Wilderness area.
Oh, okay. Anyway, so I think the question of a pilot is applicable to the entirety of the program. And I'm going to suggest that I don't know if it would be premature to consider that at the December meeting, but I think it's something to talk about at a full work group meeting in the near future, rather than at the individual committee level with respect to any particular, practice area, because it is, you guys are going to recommend it be rolled out as a pilot or not, broadly, the entirety of the program. And so maybe it's time to bring that discussion forward in December, at least to preliminarily start talking about what a pilot might look like.
The reason I brought it too, because from the first meeting, I brought that issue up, and for me, it was I was specifically thinking family law, and I was specifically thinking, when they do these pilot programs, are they doing them statewide in other jurisdictions, or do they ever do them in limited geographic areas to be able to take a deeper dive into what the outcomes are, and also to be able to make it easier to track outcomes?
They do pilots. I think the Shriver project, for example, was in maybe 6 counties, or it included LA, included huge counties. But I think you all can recommend that it be designed any way that you want to.
Okay. So with that, I don't mind deferring the pilot program discussion to the group at large, but I definitely have been advocating for that, and I'm even more so likely to do it after receipt of the letter that we got yesterday.
I would support that as well, largely because we've now heard from many groups that they're asking for that. And I think it just takes away some of the criticism of what we're trying to do. There are just two things. I too studied the letter. I thought it was well written. And I just want to say that I am not offended by the fact that if we get to licensing a group of paraprofessionals, that they might make money at it. That doesn't bother me. And we keep hearing this again and again, but I think people need to make a living, and I'm not offended by that. And then I just want to say that we all know that bad outcomes have happened when people are represented by attorneys. It's up to us, if we license a paraprofessional, to regulate them properly and to have a robust disciplinary system. So thanks.
And I think for the public participants, we should clarify, when we put Child Protective Services investigation, that was limited to the rights of parents now to obtain copies of records from CWS, which was about 3 or 4 years ago, they made the change in the law, and you get a highly redacted report. That was just to offer assistance to parents to get those, because sometimes the local entity doesn't make it easy for a parent to get the records they're entitled to obtain. That wasn't imagining that the paraprofessional would be providing counsel in a case, active CPS case.
No, in fact, dependency was one of the first things that we excluded as a group.
Okay. So, hey, Linda, can you go back to me? Is your suggestion that we just start working our way back down this list in light of the public comment and in light of what information we've gained from the discussions regarding licensure?
Well, my initial suggestion was that we just take up the recommendations that are in this to be determined status.
Okay.
But if the working group wants to revisit any of the ones that you already decided on, that's another option. But that was not my initial suggestion.
So I think that's
sorry.
I'm sorry, go ahead, Sharon.
I think that even with the things that we said are included, as we've mentioned, there's a lot more nuance to that. And I don't think it's a done deal. I think that we need to go back into every topic just to fill that out and to have more robust conversation. You know, domestic violence, for example, that's something that we've briefly discussed in the past. I know Minnesota is not including that. I think that we need to lay out the contours of what that means.
Yeah.
And I think with all of this, I know that in the letter, there was a suggestion that there's supervising attorneys. That is something that we should consider as well, if that's what it looks like in family law, as well as the 40-hour domestic violence training requirement. I think that there are some more like holistic themes that we need to discuss.
So some of this will cross over with what we're considering the regulations subcommittee, including training. So I don't know if you remember from the larger group meeting, Judge, you suggested trauma-informed training. We talked briefly about that yesterday. We had a great meeting yesterday, and we talked briefly about that. We're going to continue, and certainly we can sort of talk about, for example, what specialties. So if a paraprofessional chooses the family law specialty, then they need to definitely have as part of their 30 units or 36 units or whatever it ends up being, some of those has to be in the area of trauma informed, trauma responsive, and trauma resilient training. We can work on that, yeah. But in terms of discussion, I think it may be a good idea to talk about, is this a one-page thing, Linda?
I've actually have 3 pages, and these are the tables. This was just my attempt to summarize where we are.
Okay.
These are the tables that are directly from the memo that was presented to the full working group at its August meeting. So the first page just shows the broad subtopics, and then the next, there's 2 tables of where we
Okay.
more
Tasks.
detail on the
Okay.
task.
Okay.
Topic and tasks. Okay, got it.
So that's how
I'm
this.
on board with starting back up at the top.
Would you consider actually, since there are 2 areas on here that are on the TBD list, would you be willing to start there as Linda suggested and
Yeah,
determine
I
once
would.
and for all
I would, but
what we're going to do there?
conditional on, the Family Violence Appellate Project carries a lot of weight with me when it comes to domestic violence issues.
Mhm.
There's not, like I said, there's not, anytime I have to litigate, and I would say generally speaking, 99% of the time I'm representing the protected party in DV actions. That's just a practice choice that I've made. And I would say, you know, half of the cases I cite, they have some involvement in. So that said, I'm actually thinking about moving domestic violence to excluded or requesting that we do that, and also put elder abuse in the excluded category too.
Mhm. So are we talking about, so again, we have to kind of cross over to tasks. Are we talking about all tasks involved with these cases?
Yes.
And just blanket, or because
Yes.
they're really form intensive, a lot of form preparation, but perhaps not representation? Or do you want to completely move it off?
I'm leaning towards recommending we move domestic violence to the excluded area, understanding that I think every jurisdiction has associations, whether private or public, that provide services in the area of domestic violence and abuse. I still think that domestic violence training has to occur if the scope of services is going to include child custody and visitation issues, because even if you don't have a domestic violence restraining order, that's still relevant in terms of custody determinations. Also still relevant towards spousal support. So I don't know. That is one area where it can always be added in later, but the harm that it could occur even in one case could be so devastating.
What is one example of that harm? What would the paraprofessional do?
That instead of working with a shelter somebody elects to hire a paraprofessional who is not as experienced as the trial lawyer that gets hired by the, let's assume there's legitimacy to the underlying domestic abuse allegations. And I would put more faith in the assistance that are offered by the shelters and clinics than someone who is part of their paraprofessional studies has done the 40-hour training and had basically what looks to be a 1 semester worth of education in the area. I mean, if someone did exclusively all their work for their experiential was in domestic abuse, maybe I would be more open to it. But my concern is somebody would end up getting a paraprofessional representing them. And if in one case a restraining order was denied because a paraprofessional was handling it and didn't have as well-versed an understanding of domestic abuse laws and holdings, or some of the other training that I've gotten as attorney to deal with domestic abuse, I'd feel horrible. And maybe I'm being extremism, but I guess what it comes down to is with the tone that was taken in the comment letter that we received, it was from the Legal Aid Foundation and everybody that joined in that letter. I would feel more comfortable moving domestic violence and elder abuse into excluded for the time being, and then always considering expanding it once the pilot program proved that the paraprofessionals were effective in other areas.
What about the approach of having it be a separate licensure? So not part of family?
I think that could be taken up later, Leah.
So,
I don't want to make it like hearing from the Family Violence Appellate Project is my holy grail, but it carries a significant amount of weight for me.
Yeah, I'm going to piggyback on that and say that actually all the organizations that were represented on that letter are organizations that they do very, very good work. I've worked with them. My former organization is on there. These are organizations that deal with domestic violence day in and day out. And the fact that you have so many of them that see the high need, maybe their clients, make less money. It doesn't matter. They see the high need, but they still see the harm that could be caused. That carries a lot of weight with me as well. I would rather take a more cautious approach. Also, the fact that Minnesota, which is an approach that I appreciate, they excluded it. That carries a lot of weight with me as well. And I'd rather just get some measurable outcomes from a smaller program and be very, very successful and not have a lot of criticism because of cases gone wrong, because all it takes is a few, and then it really diminishes the weight of the rest of the program, and then revisit this and expand if there are successes.
I agree that, I think the pilot idea is great and starting on a small scale. I don't disagree that domestic violence is a highly specialized area requiring highly specialized training. Okay. Again, I'm talking about not only my county, but based on conversation I have had with colleagues across the state. So there's a lot of free form assistance available. The forms are available. Most self-help centers, most courts are providing this assistance for free. Most shelter-based agencies, domestic violence agencies are providing this assistance for free. The need is court representation. And with respect to all the wonderful people that wrote this letter, that need is not met. Domestic violence victims are not finding representation. So I'm not saying a good alternative is licensing some not untrained paraprofessionals to do the representation when the other side is a heavy hitter and hires this great trial attorney. I'm not saying that. We need to even the playing field better. But the thing is, those needs are not being met. And I want us to really focus on that. And and Sharon, you know this because of your work with all the legal agencies when you were up here as well. That is a huge need, court representation, not being met. So while we want a perfect system, you know, a Rolls Royce system, we just won't have it. So the question is, do we want to come up with something workable, or do we completely get rid of it and put it in the excluded column because of the great reasons presented? But again, nobody's suggesting how that need is going to be met. None of these agencies are going to be able to meet the need.
So I wanted to piggyback on Fariba. Thank you for seeing all of that. Let's remember right now during COVID, they're calling domestic violence the pandemic within the pandemic, because there's been an increase of domestic violence because these individuals are being trapped with their abusers. So I think it's very important what we decide, because it's very relevant right now. Now, I can speak from personal experience that when I was needing a domestic violence restraining order, there was a community organization called CORA in San Francisco, and they helped me with the paperwork. And they told me, we will get you to the court door. Once you're at those court doorsteps, you're on your own, And so they don't give representation in certain instances. And, it's a very emotional time when you're going through this and you're looking constantly over your shoulder. It was helpful that Cora was open on the weekend so that I can take time off from work. Just like paraprofessionals would be able to help individuals. Domestic violence incidents don't happen between 9 and 5. And so the more we can expand the services to the public directly, the better. And I know that there's a lot of LDAs doing this work already, and they're doing a great job, and they're helping these individuals put the exhibits together, get their stories straight. Again, it's very emotional. I personally block things from my memory because that's how our coping mechanisms are. And so sometimes just talking it out with another individual can present the best case. And it doesn't necessarily mean always giving legal advice, but I just wanted to highlight the fact that during this COVID pandemic, it's very important. That's all.
Elizabeth, do you think the harm from not including domestic violence work in the beginning is greater than the potential harm if we include it at the beginning?
So again, I feel like we're talking about what is necessary right now during the COVID. And I think eliminating more access to domestic violence could cause harm to some more, like no pun intended, yes.
Okay, so I don't think our group should be making any recommendations that are COVID specific just because of the realities. Our report's not due until September 2021. If it is pursued through legislative means, it's been suggested that this could be done without legislation, just as an administrative decision by the bar. But if they did it through the legislative route, we wouldn't see anything for 2 years. So I don't want to focus on COVID issues. I think that would be, pretend it's not COVID-19 and the issues caused by that. Would you still see that the harm in not including domestic violence within the scope of services from a paraprofessional would be greater than the potential harm to someone who did use a paraprofessional at the very beginning of the program?
There may not be any difference given that LDAs are helping a lot of the people right now with that specific issue.
Right.
What about exploring it as a standalone license where there could be additional training, more robust training? Because it does.
I like that suggestion. I think they have said it too.
Sharon, what do you think about that? That actually is, if we were going to include it, that would be my, I still haven't been won over, but if we were going to include it, that would be the issue for me.
And the category could be violence prevention, like I said. That's why I wanted elder abuse, civil harassment there too. These are highly form intensive processes, okay? And there are a lot of people who would be willing to pay a little bit of money to get the assistance like Elizabeth was mentioning. putting their documents together, calming down, getting more training that self-help centers, coaching and training that self-help centers cannot provide. And whatever we decide with regards to court representation and the training, and we can really make sure that it's regulated, and we can have training requirements and licensing requirements. And I think it'll be justified if it's over and above what we require for other fields, because it's violence prevention. And the training could be specifically for intimate partner violence, domestic violence with kids, elder abuse. Then civil harassment are not the kind of relationships, obviously, that are involved in the other two. I really like that idea.
Could we mandate that that's X number of hours of the experiential has to be working with a domestic abuse clinic or support group?
We are discussing that, and Leah can comment too. We were discussing that as part of licensing, so we could, I don't see why we couldn't add that to our discussions. Leah, what do you think?
Yeah, I think so. I mean, we've talked about putting more specificity around experiential requirements anyway.
I don't know. Sharon, what do you think about that notion of, because I think you and I kind of went to an extreme position with cause. What about that idea of it being a subspecialty or area in and of itself, and we could really hone in on the requirements and experiential?
What are we talking about? Are we talking about a separate group for domestic violence and elder abuse? Are we just talking about domestic violence? Are we talking about the preparation of documents? Or are we talking about in-court representation as well?
I treat the in-court representation as a separate discussion because I tend to agree with the letter, and I don't think my position is going to waver on that.
So I think we talk about first inclusion of the area of violence prevention, specifically these 3 types of restraining orders. And then you can talk about tasks to exclude, like definitely no court representation, okay? No deposition, whatever specifics you want to talk about. I would suggest that we approach it that way. Again, complete exclusion certainly is a step, but I would implore you to think about that before doing it, because like I said, there are people who are doing it anyway. Shouldn't we take it over as part of this program, regulate it, require specialized training, and provide that kind of consumer protection? Because there are people who are not going to be able to afford attorneys, and they'll be just doing it themselves. And we see that. And they're agreeing in hallways. Well, now with COVID, it's more visual, but they're agreeing to non-CLETS restraining orders, dropping their restraining orders. And why not have somebody next to them with proper training who could lend them that help that they wouldn't have on their own?
Yeah, I certainly have seen that. I've seen people drop restraining orders because they felt like it was a David versus Goliath situation. I'd be willing to consider a carefully regulated separate program where we really lay out the education requirements. And I like Stephen's suggestion of potentially requiring that they get the training with a legal aid program or domestic violence shelter.
So I would be willing to slide Fariba, how do you feel about the elder abuse?
I think you're talking violence prevention. The dynamics are sometimes elder abuse involves IPV over older couples, or at least one of them's older, the victim's older. But we're talking violence prevention. And I think that we should include these 3. The others that are not included are juvenile dependency restraining orders, school violence restraining order, gun violence restraining orders, and workplace violence. We're not including those.
Okay, so I would tentatively, you've persuaded me, but I want an asterisk next to violence prevention, because it's going to go beyond legal training. It's got to be the domestic violence training. It's got to be there's got to be a psychology course.
Yeah, and right? I 110% agree with you. And there's no reason attorneys shouldn't be told they have to do this. Of course, that's a whole other discussion. But really, honestly, how many attorneys do you see take these cases and they don't have trainings, right? But I totally agree with specialized training, and I hope somebody's taking notes, because we need to discuss that in the other.
I always just count on Linda to do it for us.
Yeah, we are.
Okay, so yes, sliding TBD elder abuse over to included with that asterisk that's going to have to definitely be fleshed out both by this group and by the licensing and regulation.
And again, I just want to clarify that I think it's a great idea to have a violence prevention subspecialty or specialty. So as one of the family, violence prevention, whatever, civil, whatever, all the specialties, this should be its own. And we can handle it in this group, but I just think we should have that because then we're able to assign requirements to it, training requirements.
Okay.
Right.
We had conservatorship as a TBD.
Okay, so are we talking all kinds of conservatorships?
I'm kind of thinking, okay.
I think you all made a distinction between conservatorship of the person and conservatorship other.
Of the estate.
Yes,
So,
and
yeah.
the estate was excluded.
Limited conservatorship is, as you probably know already, it's conservatorship of a person that has been disabled since being a minor child. And we actually have a workshop here that's very popular, and we have a 4-month, wait list. So that's something, it's very form intensive. It's kind of like guardianship. Parents do it on their own. There's in our county, there's one agency, but they collaborate with us. So I don't know what kind of assistance is available out there, low cost or no cost. But I would think it's very form intensive, like guardianship. So I think there shouldn't be and usually court representation is really not necessary. There's really no litigation. It's parents, taking over the affairs of their developmentally disabled child. What do you guys, that's limited conservatorship.
Do we remember why we put it in the TBD? Because do we just not have time to break out the discussion about what's involved in conservatorship?
I think so. And weren't we going to talk to experts in the area? Like I know that there are folks from Vetzedic that do both elder abuse and conservatorships. And I think it would be beneficial to have a conversation with them. Unless we have experts in the room.
That would be a no. And I was wondering, in those conservatorships, Fariba, does the child or the then now adult, do they automatically get appointed counsel by the court?
I have an expert on my staff that I can contact really quickly to confirm that.
I'd love to talk to somebody just to pick their brain about it, because that's one of the ones where I'm still really reluctant.
Even on the limited conservatorships.
Yeah.
Mm-hmm.
Sorry, I'm not trying to.
I know enough to not be too concerned about limited conservatorships because they're often not opposed, and it's a matter of just getting through the process. Conservatorship of the person, the other kind of conservatorship, that's more involved because that's where you could have opposition, and we have experts on our staff for that too.
So what you're talking about is when we've got a adult dependent child that previously has been determined to have needs, and is that what you're?
So that's limited conservatorship. So they turn 18, and now the parents need to apply for this to be able to continue to control their legal affairs.
Okay.
And they're very rarely opposed.
That's right.
I have nothing else to add to that conversation. I'd be relying on others.
Can we move limited over to the included column and actually name the other two and leave them in TBD for the time being?
I would actually, the other two, I probably would say exclude.
I tend to agree with that. But
The other two?
Conservatorship of the person and state.
Okay, definitely conservatorship of the estate.
Yeah. So
have to take this call.
Linda, when you rewrite this, I would put 3 subcategories under conservatorship. And that way you could put included and excluded on each. So the limited conservatorship would be included. Conservatorship of the person would be excluded. Conservatorship of the estate would be excluded.
Is everyone in agreement with that?
Are there any nuances for limited conservatorships that we're not thinking about?
Are you
Hold on,
aware of
hold
any
on,
data?
hold on. Hi, my apologies. I'm actually talking to the staff attorney, my staff attorney who's an expert in limited conservatorships. So I'm right now asking her if most of these are unopposed. And she's saying yes. Now, will the minor be appointed a counsel automatically as part of this process?
That's a good question.
Public Defender's Office has a probate attorney that is assigned to the minor.
So they've got representation automatically. That's what I figured.
Any
Okay.
other questions?
And
Yes.
then when these limited conservatorships, do both parents have to join in on it, assuming that their parental rights haven't previously been revoked or taken
No,
away?
they do not have to join in.
Okay.
So I would just say that I know you guys are categorizing it as limited conservatorship. We would, if there's not a big difference between the limited conservatorship and the regular conservatorship of the person, then I don't see why we leave it in included. I agree with excluding conservatorship of the estate, but just wanted to make known that if conservatorship is conservatorship, whether it's limited or non-limited, that's my standing on it. I just wanted to make that known.
And I think the LDAs, you submitted a letter to that effect when the original discussion about estates and trust happened, if I recall. I think Ian Duncan submitted a letter to the group on that.
Yeah. So the difference between the two kinds of conservatorship is the range of powers that are granted. So for limited conservatorship, there's specific powers that are granted to the parents. And could you tell me what those are? No, I know I put you on the spot. I'm sorry. I didn't even think about to schedule her to talk to us. Okay. Yeah. Okay. Choose where the dependent adult lives. Okay. Access confidential records. Control the right to contract. Withhold medical consent. Education. Habilitation or treatment. Is that what you said? Okay. Training, medical, psychological, social and vocational opportunities. And their duty is to help the conservatee develop their skills and become independent. Thank you. Is there anything else?
That's for the limited conservatorship?
Yeah. Just imagine what powers the general conservator will have.
So based on that, I'm still comfortable with us including limited conservatorship and excluding general conservatorships.
Right. I would agree with that. All right, Linda, thank you. Bye. I would agree with that. And I think that general conservatorships are more often opposed than these are.
Do we want to, just to be thoughtful about Elizabeth's position, do we want to invite someone to come to talk about just general conservatorships, or no? It sounds like there's consensus on conservatorship of the estate. Yes,
Correct.
but conservatorship of the person.
Elizabeth, do you do that work now? I was
The
wondering.
LDAs do it, about 35% of them.
And you wouldn't have any idea on what their experience is with the general conservatorships in terms of opposition, how often they're litigated?
I know we have Helen Bellamy as an attendee who's been doing this for over 15, 20 years. And
Okay,
she's able to speak, if you guys would allow her to, as an LDA and doing conservatorships. She would be better able to speak on, the actual details.
could we, or is that not allowed, Linda and Leah?
I think we can. If you
We
want to
can.
Yeah, I've just brought her into the discussion. So Helen, if you want to unmute yourself, you can speak to these and maybe answer some questions. It looks like you're still muted, Helen. There you go.
Hi, how are you? Thank you so much.
Hi, Helen, thank you.
I am listening to the conversation, and when people call me with reference to a conservatorship of the a general or what we would call a probate conservatorship, you've got family members who are trying to take care of mostly their parents. And I don't actually provide services to families that are in litigation or who are actually in dispute. I think that if you're thinking of anything, you want to actually have the paraprofessional, the LDA, provide the paperwork, because it is very form intensive. You've got the doctor, you've got an investigation that's going on. And if at any point when I provide services, if it starts to get to be litigated, I turn it over to an attorney, because I don't have the scope of understanding to actually help people litigate those type of issues. But most of the time they are not litigated. This is me wanting to take care of my mother. This is me wanting to take care of my sister, my father, or something like that. So I think that this idea that families are fighting each other to take care of their parents, just not true. That is not the norm.
What about
I just provided services, excuse me. I just provided services for a family of a gentleman in San Francisco who was in a car accident. It was him and her and her mother who came together to take care of her brother. So I think when you put a human face to this and not this nebulous animal that says that everybody's at each other's throat, that's not true in conservatorship. We do know that people fight, but that is not the norm.
Does the conservatee get an appointed counsel in that case?
Yes, it is. Yes, they are. And the court investigators are wonderful. I'm able to actually help my customers understand something, that the conservatorship process, especially for the person, it's not adversarial at all. Everybody's trying to help take care of the person who needs help.
Would you say that it's a good idea to, if we do decide to include conservatorship of the person, to have an exclusion, have an asterisk for exclusion of litigated matters?
I think that it makes more sense. And when I actually teach the class on conservatorship, I help other LDAs understand that our job is not to help people fight in system. That's not where our training is. You have to know when it's time to pass the baton. But I'm literally talking about, we're filling out all of the necessary forms, the petition, the confidential, the supplemental confidential, helping people to actually understand, getting the doctor to actually do the capacity declaration, making the notices taken care of, making sure that the examiner notes are taken care of. This is, one of the, and I could go on and on, but one of the things that I think that the committee has to understand, that the Judicial Council has all of these forms for a purpose. They're looking for uniformity. And you can teach people. I've been doing this for too many years to know that this is process that we're talking about. That's why a paralegal can do it. It's process. This is not theory. This is not, where we're trying to figure out what the law is. The law is very plain, and now we just have to get people through the process.
Thank you.
Thank you,
Helen.
Helen.
You're
Thanks,
welcome.
Thank you.
Very helpful. what do you all think
I
to,
think that we should maybe table this because I also want to hear from Beth Zedek. And rather than just excluding today, I take what Helen says very seriously as well as Elizabeth. And I think we should have a more robust conversation on the contours of conservatorship.
general conservatorship?
Yeah, generally.
We've already agreed on including limited conservatorship, or you want to table that too?
I'm okay with including it now.
Okay.
I'm
I
okay.
wouldn't mind exploring conservatorship of the person. I think it's worth doing that, definitely.
So sorry, Linda, we still gave you a TBD.
Yeah, for one of three.
So yeah, you can subdivide conservatorship or have two categories.
Yeah, the estates excluded, limited conservatorship. It sounds like we're included. Of the person is the TBD. Okay.
Yeah, just call it general conservatorship, limited conservatorship, and conservatorship of the state. I think that's probably a good way to refer. Yeah.
Okay.
Ooh,
Linda,
great work, guys.
Love that.
I was going to ask a question. I don't want to put her on the spot, but I see our potential new chair is in the attendees. Did she want to stay outside the room?
I don't know. We can invite her to answer your question.
Who is it? I'm sorry.
Justice Petru's in the attendees.
yes, we haven't actually sent out a formal notification, but she has agreed to be the chair, and we'll be sending that email out to all of you soon.
Yeah.
We can.
Justice Petru.
Out of the bag.
I want to meet her in a small group, not a big group.
Are you able to hear me?
Yes.
Yeah.
Yes.
Well, hello.
Hi there. Sorry, I put you on the spot, but I
No,
figured it's too good of an opportunity to talk to you in a small group setting.
No, I'm in a full eavesdrop mode. So what input would be helpful for me, if any, at this point?
What was your trial court experience? Everything?
Oh, my trial court experience. So I was with the Alameda County Superior Court from 2010 to 2018, at which time I moved to the Court of Appeal. And while I was on the trial court, I had a couple of short-term criminal assignments. And even though before that, I'd actually done much more criminal in the federal context. And I did family law for probably about 20 months or so. So I had a family law assignment, which has certainly been informing, as I sit here listening to all of this. And then I had primarily civil assignments, general civil, which in Alameda County includes the case from inception through death, essentially the whole way through. It's a direct calendar assignment system, unlike San Francisco, for example, and also complex litigation. And I also was the supervising judge for a period of time for the entire civil division. So had some involvement at that time with helping to kind of restructure the settlement departments and some other things. And also in, a lot of discussion about how to handle the categories of civil cases that had a very high percentage of self-represented litigants, like the harassment calendars, the unlawful detainer calendars, of course, small claims.
Did they do the conservatorships on the probate calendar in Alameda?
Yes. Yes. So a smattering, a variety of assignments, some of which were directly relevant to the committee's work.
Welcome.
Thank you.
Do you all want to turn to the following slide, to the task discussion? I know we have a little bit more time, or do you?
I will defer to the group. I can go either way.
So I think the tasks are where we get, well, I think there's another level of discussion when we're talking about areas of law, is that complexity. So we talked about dissolution, but then we're going to talk about exactly what is entailed. For example, parentage. I think that complex competing parentage presumptions should be excluded, because those require very detailed legal analysis, and we see them often. That's where a birth mother is married but has a child with another man, and now we're looking at 7611A, competing presumption. You may have DNA, you may, so I think that when we're talking about parentage, I would, for example, vote to exclude competing presumptions and parent challenges, and just the whole area of challenges. And I don't know if you agree with that, but I wanted to put that forth and ask, should we next discuss those types of issues or move to tasks?
So you're like dealing with like the Kelsey S parents not having.
I mean, challenging VDOPs, and I mean, the full array.
It's kind of like undisputed parentage. Although technically you probably wouldn't have a problem with a paraprofessional helping if all it was the genetic testing.
Right, as long as we're not talking about heavy duty competing parentage issues and litigation around that and analysis. It's even hard for people who don't do it as a matter of practice, attorneys who don't do it as a matter of practice, to do that analysis. And I'm talking about attorneys who've been in practice for 30 years. So we do it often.
Yeah.
We run across it here often.
I think the tricky part is how do you describe it? It's kind of like, you know what it is when you see it, but how do you explain it? You and I know it.
So if you're excluding this sort of competing or challenges to parentage, then what's included in parentage?
Just a finding of parentage, establishing the parental relationship, which typically is going to get done through the Department of Child Support Services in probably 90% of the cases, if someone doesn't have private counsel.
Yes or no? Yes and no, because I mean, Department of Child Support Services gets involved automatically if a child goes on aid, but otherwise there has to be a private case. So we do see a lot of the UPA actions opened up, and they're mostly straightforward. Parents were unmarried at birth. They signed a voluntary declaration of paternity, which was filed with the Department of Child Support Services. But that's because that's where they go. It's not because department is involved. So we double check and it's not an issue. It's a nobody's challenging it. There is no challenge, and that's it.
Would you include challenging the VDOP? You've only got that limited time window to do it.
I would say to you that there's a judicial counsel form for that, and I really do think Helen's comment is right on point, because judicial counsel comes up with these forms in straightforward cases, just to make it simple and easy to understand for self-represented litigants as well as attorneys. And I think uniformity and consistency and all the statements are there. It's really easy to do. So I think that for challenges that are within the statute of limitations, I would agree that they could be perhaps included, but how easy it is to delineate between those challenges and more complex challenges.
Can you explain what a VDOP is? I don't know what that is.
Voluntary Declaration of Paternity. That's acknowledgement of parentage between unmarried people.
It actually establishes the parental relationship. You don't have to go to court and get a parentage finding. And if you have the VDOP, which usually is going to be signed at the hospital, I mean, they're trained to get obviously the father to sign the VDOP at the hospital.
Okay.
And if that exists, then your paternity is presumptively established with the VDOP. Whereas if it's not signed at the hospital, the father would have to go and establish his parental relationship before he's going to be able to get custodial time.
So as of last year, the terminology became gender neutral. So it's birth parent and the other parent. So two women can sign it, and a married birth mother cannot sign it. It's only unmarried birth mothers can sign that.
Yeah, I'm sorry, I should have put that gender neutral.
Yeah, it's 60 days. It's revocable administratively, unilaterally by one of the signers, and 2 years for judicial revocation. Set aside.
So Fariba, you're suggesting complex competing parentage presumptions. Those types of parentage matters should be excluded. The question, how do we describe that in a way that's like a clear,
Yeah.
you know, red X?
Good
got-
question.
Claims under Family Code Section 7612B and C.
C is the multiple parentage, isn't it? Or is
Yeah,
it- Yeah.
that's a complex one too, because you've got to weigh, is it more detrimental to the child having the third parent relationship? or taking it
That's a
away?
new aspect. So
Yeah, I
let's
had it.
talk
in my
about
case.
competing presumptions. So one way you can do it, it's very black and white, is no challenges to paternity.
But the reason I
But you
said,
want to do that.
the reason I didn't go that language, because what if paternity hasn't been established, there's not been a VDOP, and the presumed biological parent says, I'm not the father, which would typically would be the situation. And so he's challenging paternity there, but it's just it's just going to be getting the genetic testing, right?
Mhm.
So that's what, if you look at the language under so 7612B is when there's two competing presumptions for parentage, which is what you were talking about. And then I included C because that is an especially nuanced argument.
I agree. I agree with including C. Yeah.
Does anybody else have any feedback or comments on this?
Does it work to say, to draw the line at contested?
No, because again, if the VDOP hasn't been signed at the hospital, then technically the biological parent could contest it. And that's not a complicated issue. That's just getting genetic testing in order to see if there's the biological connection. So the issue that Fariba was talking about is this case where you've got two competing presumptions. One parent's the biological parent, the other has been nurturing the child for the last year and a half. And the question is which one of them should be determined the parent, or should both of them? So I think those,
I'm sorry, go ahead.
I really do think if we do, because we're making it very specific and clear then, parentage except for claims or issues arising under Family Code Section 7612B and C. That's a real bright line delineation and addresses Fariba's concerns.
Yeah, it's kind of like subject matter jurisdiction where it's not waivable. I mean, either there is jurisdiction or there isn't. So if, for example, a VDOP is void because a married birth mother signed it, it doesn't have to be contested for it to be void. It's void by operation of law. You see, so these are issues that are going to have to be determined by the court before the court can move on to other issues such as custody, visitation, and support.
Good. I'm good with Stephen's suggestion.
I just wanted to make a comment, just my experience with the parentage. When people are looking for that service from legal document assistance, it's because they want to get a passport so that they can get an order that says that they have full custody so that they can get a passport. Or sometimes they just want, the parents want a written order so that, like Fariba said, custody and visitation can be established when it's not part of a divorce case. So to me, I know a lot of the LDAs do it just because it's just a process for another means. It's a stepping stone to what they really, really want.
Right, but step one is determination of parentage.
Yeah.
Always in those cases. And then after that.
Okay, so where are we?
I like Steve's suggestion. Too.
Okay. All right.
I'm okay with it.
Do you have,
Otherwise, in parentage cases, once the paternity issue is dealt with, then you've got custody visit. And sometimes parentage is not an issue, so it doesn't have to be dealt with, So then you move on to other issues. Only other two issues are custody visitation.
How come we don't have that on the chart of this screen that's on there?
What?
How come we don't have,
custody and visitation?
yeah.
Because
Is it on?
I think it'll be under the solution under parentage, yeah? And
Well,
sometimes in domestic violence and in domestic violence cases.
that's what I was saying is it's whether it does come up in all of the individual areas.
Where is it, Linda? I thought we had it.
Let me go back to the original memo.
And there's another type of case we don't have here, not often used, but is petition for custody and support. So if we're going to be that specific, that is to empower paraprofessionals to be able to handle that case step, I think we should include it.
This was an error. This is an oversight on my part. Custody and visitation. When I transcribed it to this slide, I left off custody and visitation.
Okay.
Yeah.
I
Good
thought
catch,
we'd
Steve.
identified that as a separate area because
That
we
was
were,
included under, that was in the included category. I apologize. That was an
Okay.
error on my part.
Hey, Linda.
And with regards to custody, visitation, and support, are there any areas we think should be excluded? So for example, you've got an emergency screening issue, substance abuse, DV, child safety issues, basically.
I don't know yet.
This could be a starting point and we can flesh it out later.
Yeah, I think,
I do think we need to flush it out. I wonder if we have any time to do so today.
No, I think we do today. But Fariba, you mentioned something else that I wanted to make a note on. You said there was another type that was missing.
Petition for custody and support.
And what is that?
Did you ask what it was?
Yeah.
Okay, it's a kind of case that can be used by married couples who don't have a pending dissolution or legal separation action or nullity. And it can also be used by unmarried couples who where parentage has been already established and is not questioned, because you cannot establish parentage in these cases, nor can you divorce people. There's no right to ask for spousal support either, even if the parties are married. So it's simply a case for custody, visitation, and child support.
Okay.
Not my favorite type of case, because married people always turn out to want to divorce later. So now you got two cases in the system. And then unmarried people do it, but they often don't understand what it means that parentage has been previously established. So they need that parentage judgment. So now they have to open a parentage case. So
Okay. So I think we walked through some of the specifics of parentage and created a carve out, still in the practice area discussion, not in the task discussion. It sounds like there may be additional similar activity that needs to take place with respect to all of these, right? We were just talking about child custody, but it could be dissolution. Are there dissolution types that would be excluded?
So parentage issues actually come up in dissolutions as well. So I would suggest repeat the language, except that I think, Steve, we may need to refer to 7540 as well. Or is it just, no, it's still competing presumptions, right?
yeah.
Okay.
7612 is the one that's got the competing presumption.
Okay. So same language.
Yeah.
Okay. And then what else?
Would you just kind of a side issue, but it came up in a reported case. What if one of the parties isn't competent and they need a guardian ad litem to pursue the divorce?
Actually, in my litigation days, my client in the middle of the case suffered a massive stroke at 37 years old. Yeah, we had to get her brother to become her guardian ad litem. So yes, happens. What do you think should be done with that?
Should that be an area where a paraprofessional cannot be hired by the guardian ad litem, where the party is represented by, where the party has had a guardian ad litem appointed? You know why I'm saying that? Because because I could see a scenario where, and it would be no fault of the paraprofessional. So the guardian ad litem wants to keep the estate as big as possible for when they inherit it, because usually it's the next, it's a survivor that gets appointed as the guardian ad litem. And so they decide not to hire a lawyer and use a paraprofessional to keep the estate as big as possible. I could see competing financial interests there. May not be a big thing, but it came to me.
So I'm right now just kind of thinking about complexities rather, and I don't know if that's the same thing.
So we excluded, I think, an excluded task was the quadro or the quattro, can't remember.
Qualified domestic relation order, absolutely keep that one out.
But is there a parallel to this discussion in terms of complexity of the type
Task.
of dissolution? Meaning we kind of talked around but never got to high net worth. Like if the assets are over a certain dollar amount, would the matter not be eligible for a paraprofessional? Or if there's certain type of asset. So I'm just wondering.
From my experience, I would say that there's complexities that automatically appear in high net worth, high income cases, cannot be avoided. Even when you're running child support calculations, running child support calculations for a person, for a couple that basically makes maybe, 70,000, 50,000, whatever, is totally different than when they make 50,000 a month. And in this valley, we have them. And they actually represent themselves. There's some strategies and tactics that have to be run that we don't even do it in this office because it's really tantamount to legal advice at a higher level. I don't know what Steve thinks about that.
I'd actually want to ask Elizabeth a question. Is there some level of the size of the marital estate or some level of income where you as an LDA say you need to go hire an attorney? Do you have any kind of threshold?
So the LDAs are not limited to a threshold. They take on anyone who's asking for help who doesn't need legal advice, and they do the form preparation. Like Helen mentioned earlier, when there are maybe high assets, then the LDA can refer them out to attorneys and can have the attorneys give them consults. And in fact, when they sign that marital settlement agreement, a lot of the templates online say, I know that I'm representing myself. I know that I could have gone to an attorney. Nonetheless, I choose to sign this marital settlement agreement. So no, there is no financial cutoff. I mean, we are living in the Bay Area where we have the Facebookers, the Silicon Valley, they make a lot of money. And so, no, there doesn't make sense to limit it to, oh, we can't help people just because they make over a certain amount. That's my recommendation.
And I was totally putting you on the spot. I was asking you personally, if someone comes in and there's a business asset that has to be valued, will you take that client on sometimes? Or are you de facto, you'll say, no, I need to refer you to an attorney?
So so it depends. If they come to me and they tell me we have already made our own agreements based on our own, either speaking with mediators or attorneys, I remind them that all I can do is type up their agreement, how they have divided everything. I've had some high-end clients and still do, but they have consulting attorneys. And like I said, all I do is form preparation.
So you're not getting, so actually I could see where the LDA could have a more expansive practice because you've got that insulation of, I'm not giving you legal advice. I'm just your scrivener. I'm putting this on the right forms so it gets past the clerk in Department 5 or whatever. So I think Fariba, I think that, can I work on this before our next meeting?
Yeah. So before anyone answers that question, let me just kind of pose these questions, which we think about here. From a consumer protection standpoint, and not talking just about legal documents, I'm just talking in general. If in the future something happens, a provision is not enforceable, unbeknownst to you, one spouse was being duped and forced and signed under duress. Again, there are a lot of these issues. And I wonder, Elizabeth, if you've ever experienced somebody coming back to you and kind of pointing the finger at you and saying, you did not do this right because now, I can't do X. And as a group, do we want to even think about that as a factor in including in not putting income limitation and asset limitation?
So that has never happened to me, right? That they've said that, but it can happen absolutely through no fault of my own. It can happen if an attorney prepares these documents, right? You have two individuals who they decide they don't want to disclose certain things on their financial disclosures. We can only provide them with the forms that they know that they need to fill out because, you know, Court Access Center has given them the packet. So we can only fill out the forms that they tell us to fill out. So can it happen? Absolutely. But, you know, I haven't, in the 5 years that I've been strictly doing divorce for self-represented individuals, I have not have that experience. I did work with a mediator for a couple of years, and he did have one person come back and say, I didn't get disclosures, and that's being litigated. But if, you know, between the time I worked with him and the time I don't see it. And it can happen, but it's not common. It's not common.
So this conversation is my fault because I suggested as a way to keep us moving forward that would people feel more comfortable if we had income limits. And at the time, I think my memory is that most people said no. But I think that's what Leah's remembering, that I was the one who raised this. So I'm sorry if I got us off track.
No, I don't think you got us off track because this was an issue for me.
That's
And
a
I think
valid point. Yeah.
Yeah, I think if somebody is an LDA like Elizabeth that's doing it ethically, they're not taking a legal position with regards to Epstein-Watts issues, or, you know, whether there's a Pereira separate property interest in a business. She's not telling those clients what the legal outcome could be, should be, and what the legal arguments are. We're empowering paraprofessionals to do that. So I think it is appropriate. They're going to be in a completely different role. And the question is, should we put a monetary limit on that? And I think that's fair. That's why we said, give me till the next meeting.
I'm also thinking about lopsided cases that we often see in domestic violence situations where, you know, maybe the husband who's the abuser was controlling the funds, and he hires a high-powered attorney. You know, sometimes you could get attorney's fees for the other side. And, you know, what about those cases?
Yeah, I think
So
I'm sorry.
I just want to adjust a passport because it's 3 o'clock. Linda, if you can send out, not this slide that's up, but the previous one as modified to reflect what the discussion today. And then between now and the next meeting, if each of you can think through for the practice, the areas, the sub areas now within family, and then we created this separate licensure idea for violence prevention. Are there exclusions that you would recommend? And if to facilitate that conversation, you want us to invite anyone to attend the next meeting who's a specialist in any particular area, you can let us know. We already have conservatorship of the person. We know general conservatorship. We know we'll invite Beth Sadek to come and speak to that. But if there are additional areas that you want to explore, you can let us know so that you have time to think this through. Because I would hope by the end of the next meeting, we could get through all of the excluded subtopics. So then we can turn to tasks. How does that sound to people?
Yes, with the proviso, I'm expecting to come up with some suggestions for excluded areas within division of assets and debts.
Okay.
And I think I would like Beth Zedek, since they have so much expertise, to weigh in on conservatorships, but I think that they also have guardianship experts and elder abuse experts. And I think that we just have to flesh out these areas a little bit more.
Okay. Okay. So we'll reach out to them at least on those topics. And then if any additional come up in the course of your review of this chart as modified to reflect what we've decided today, just let us know and we can try to schedule getting additional people and experts to talk to you.
And the experts should be non-biased, I believe. If there's any way that we can make them like neutral, where they don't have one, obviously they're going to have an opinion, but like if they can be neutral.
I don't think we'll be able to get neutrals. I think I think we have to get experts on the opposite sides.
Yeah. There's no neutrality when it comes to paraprofessionals.
Maybe the judicial officers, I think, you know, finding judges who have expertise in some of these areas. I don't want to kind of waste their time if it's just a 5-minute discussion, but maybe if we get to some where you think there's really going to be an extended discussion, that's where I would think we might go to find the more neutral voice.
So I guess process question, in addition to looking at the areas that we have tabled, are we going to systematically go through like the remaining areas that were in the included categories to flesh them out some more?
Yeah, I think that's what we're talking about, right?
Okay.
Yeah, I'm volunteering to do that for the division of assets and debts.
So the way I look at it is in dissolutions, the issues for every dissolution, if there are kids issues, if there are kids, then there's spousal support, then there's property division. And I think we should address each one of those, even if to just say, okay, custody visitation dissolution matters, no exclusions. Okay. And parentage, we already talked about, is the parentage issue, custody visitation, child support. You can ask for a name change and costs of pregnancy and childbirth. Again, I think systematically just going through what requests are allowed under each case will provide us with a good framework, if people agree.
Yeah, I like that approach.
Okay, thank you. And then domestic violence, we could have cases with kids, cases without kids. And so, and also in domestic violence cases, independent domestic violence cases, there could be, when the parties are married, there could be a right to spousal support and temporary property possession, no permanent orders. And again, I think that we have to look at under each case, those sub areas that are covered in each case and decide whether we want to include them or exclude them. For example, if Steve, you're talking about division of assets and debts, even though there couldn't be a permanent division in an independent DV action, there could at least be a decision.
Right, temporary possession and control, or possession and control, right?
Right, and freezing of accounts, for example, things like that.
I'm sorry, but I'm late for another meeting.
Okay, all right, we have enough.
I think
you should distribute the slides as modified today, and then I'm going to work from that.
Yeah, and Fariba and Stephen, to the extent that you can help flesh out, just like you're doing right now, Fariba, what the sub areas are, then I think that will help us advance. So maybe we'll reach out to you both separately.
Okay, no problem. Happy to do it.
Thank you.
Bye,
Thank you,
everyone.
everybody. Have a great day.
Thanks, everyone.